We will now begin today's webinar.
On behalf of responsibility.org, welcome to today's webinar, Jury Selection in Impaired Driving Cases, a Guide for Prosecutors. I'm Darren Grondell, Senior Vice President, Traffic Safety in the National Alliance to Stop Impaired Driving for responsibility.org. I'd like to thank Christiana Falcon and Dr. Ryan Smith, who you might see on the screen, as they are providing all kinds of technical support for us for this webinar. Uh, we're not getting the slides advanced. There we go. Founded in 1991 by America's leading distillers, Responsibility.org is a national independent, not-for-profit organization working to promote a lifetime of alcohol responsibility. Responsibility.org's threefold mission consists of eliminating underage drinking, eliminating drunk and impaired driving, and empowering adults to make a lifetime of responsible alcohol choices. You may not know this, but April is Alcohol Responsibility Month. This is a time to reflect on the choices that keep us and those around us safe. Responsibility starts wherever you are, at home, at work, on the road, and in your community. Most importantly, responsibility starts with me. We invite you to visit responsibility.org to learn more about all of our programs. We've got a lot of resources for you that you can check those things out at responsibility.org. Now, since 2010, responsibility.org has partnered with the National Traffic Law Center to provide ongoing resources and training to support our nation's prosecutors in their efforts to eliminate drunk and drug driving. We are honored to host today's webinar, made possible through the generous support of our funders. Today's webinar will explore effective strategies for selecting potential jurors based on the recently released publication, Jury Selection Impaired Driving Cases, created in partnership between Responsibility.org and the National District Attorneys Association's National Traffic Law Center. Our speakers will address key facts, witness selection strategies, and legal challenges while also offering guidance for identifying biases, including empathy toward defendants and even skepticism of law enforcement. You will come away from this webinar with actionable insights to strengthen our approach in the courtroom as part of the complex DUI system. And now, here's my friend Aaron Inman, Director, National Traffic Law Center, National District Attorneys Association, to kick off the webinar and introduce today's panel.
Thank you, Darren. I'm just taking control of the mouse. And thank you, everybody, for joining us today. I'm excited with our discussion that we're going to have about how to get a fair and impartial jury in impaired driving cases, how to go about doing that, some practical tips, like Darren said, for prosecutors, for our line prosecutors and supervisors. And if you're not a prosecutor, I hope you enjoy having a glimpse into what it is that we prosecutors do on a daily basis. I am honored as director of the National Traffic Law Center with the National District Attorneys Association to lead a team of 4 attorneys and a project coordinator. And our goal is to assist prosecutors across the nation in effectively prosecuting traffic offenses. If you have any questions about anything traffic, please feel free to reach out to me and I will send you to the member of our team who can best answer your question. Today's webinar, as Darren said, is based largely on a monograph that we created thanks to the generous support of responsibility.org. You can access that monograph here with this QR code, or we'll make sure that there's a link to it. It's free to anybody who wants to take a look at it. In the chat, we will get a link to that, and you can access it anytime you'd like. As for our speakers and facilitators in today's webinar, Erica Dobbs is the Traffic Safety Resource Prosecutor in Indiana. You won't see Erica today, but for this picture, Erica is going to be in the background answering questions. I encourage you, as we're going through this webinar, if you have a question about something that one of the speakers is saying, please pop it into the chat and Erica will go ahead and answer your question, or she'll hold it until the end. And there will be some, sorry, I was just checking out a little message from Erica. We're just testing some background things. There will be some time at the end of this webinar for questions. And so if there's something that comes to you at the end, please feel free to ask that question then too. Everybody's chat should be working if you check the little bubble down on the lower part of your screen. Our first speaker today is Chris Daniels. He's the Senior Traffic Safety Resource Prosecutor in Indiana. He will hand it over to Ed Hirsch, the Senior Assistant Montana Attorney General and the Montana Traffic Safety Resource Prosecutor. And then my colleague Stacy Grachik, the Senior Attorney at the National Traffic Law Center, will close us out. Again, I'm excited for what you're about to hear. And with that, I will turn it over to Chris to get us started.
All right, got my audio on. Good afternoon, everybody. Just waiting to be able to take control of the presentation here. Haha. There we go. All right. So like I said, my name is Chris Daniels. I'm the Senior Traffic Safety Resource Prosecutor here in Indiana, and I've been in this position working on impaired driving cases now for 20 years. And obviously, a huge part of that is jury selection. I work with the Indiana Prosecuting Attorneys Council, and a massive part of all the training that we do is we ask people, what do you want to get training on? What do you want to get better at? And without fail, jury selection has always popped up as a requested training and a skill. And so we really spent a lot of time trying to develop a great course in terms of what are some of the most modern things that we can do in terms of jury selection. Because everybody that we talk to about it has been doing jury selection under roughly the same theory for decades. And generally, it's a theory that works. A lot of the prosecutors that we talk to about it are great at their job. But what we found without fail, when we talk to our good prosecutors, when we talk to our prosecutors who are handling all these difficult OWI cases, and we'd ask, what went the last time something went wrong in one of your cases, what happened? And almost without fail, it was a juror. A juror went sideways on us. Something crazy happened in the jury room. Because at a certain point in your career, you know your case. You know, you're good at getting your witnesses. You're good at presenting your evidence. Your witnesses are ready to go. You got your drug recognition experts, your crash reconstructionists, your law enforcement phlebotomists. We have some of the best law enforcement here to come in and work with us as witnesses in these cases. We've got our chemists. Our entire case is put together extremely well. When things go south, it's because a juror has gotten, one of those crazy jurors got through. And so we spent a lot of time trying to develop a course to re-examine the way that we'd always been doing things. And well, the way we've always been doing things is done pretty well. But as always, how could we do better? And so we spoke with a lot of civil consultants and jury consultants and put together a course that really changed how a lot of us in Indiana thought about jury selection. And since we've really started teaching this new course, we've received a tremendous amount of feedback to how it works in the field. And those crazy jurors aren't getting through, and we're getting better, more consistent, and faster verdicts in a lot of these cases. And so that's what, usually it's a 3-day course when we put this on, and we're going to try to condense this into about an hour. And I've got about 25 minutes to talk to y'all about our piece of it here. So, what jury selection, what voir dire used to mean to me, and I stress used to me. Look how young I am in that picture compared to now. But it was a way of thinking that I think a lot of prosecutors, a lot of attorneys still think about it. First goal was to make the jury like me, win them over myself so that they hold a high opinion of me. Try to figure out which jurors are crazy. And then probably the most important part we always focused on is how do we indoctrinate, condition, educate, whatever phrases we like to use to condition our jurors to our perspective, to lock them into our way of thinking during jury selection so that we would keep them that way throughout. And this brought up a lot of concepts that we were talking about in terms of how we have to be careful not to poison a jury. We have to be careful about, what language we use, how we would want to get the jury thinking like us. And we've tried to abandon a lot of that. There's a concept that while it has generally worked, I go back to the idea that no one's ever changed anybody's mind on Facebook. And those jurors, when they come in, we're not getting them to change their minds about any of those firmly held beliefs. And it doesn't matter what tricks we like to use as prosecutors. We get each juror to promise that they're going to do something or to make a promise to us. And they don't care about us. They don't know us. What they do know is all the life experiences that they've had to come in. And so what we really try to focus on is how do we identify who these jurors are? How do we get them to talk and find out whether or not this is the right case for them in our case? So we kind of boiled this down to 3 new main goals. The first one is identify and remove jurors who are biased. Anybody who comes in with a bias, who this is not an appropriate case for them, we want to get rid of them. And I'll talk more about this in a little bit, but I don't care if they're pro-defense or pro-state. We're trying to get rid of anybody that has a bias. And we're going to do that by developing a rapport with the jury. It's not about making them like us. It's about creating a culture of disclosure where they feel comfortable talking to us, where they're willing to talk to us about their life experiences, their biases, and how they view the world. And we're going to do all of that so that we can build a team of jurors who will work together. It does not matter if someone is one of the best jurors in the world and they might be pro-state, but if they get in a fight with somebody else back in that jury room, your jury hangs. We can do the best job as prosecutors that we can. We can get all the evidence laid out in the best way possible. But if something weird happens in that jury room, that is completely out of our control. And when that really happens is when we have not built a team back there that can work together to reach a decision. Waiting for the slides. I'm very tempted to mash the button, but then I know I'm going to accidentally advance like 6 slides in a row here. So a few of the things that we're going to talk about is, what are some of the phrases that we use? And I'll say the first time that I ever attended a course that was based on this concept, and we were talking with some of the civil jury panelists, consultants, and people who study the psychology of this, is how much the words we say matter. And we spend a lot of time talking about this when we talk about direct, when we talk about cross, when we talk about close, the power of language. It applies the same way when we're doing jury selection. And so I'm going to give you guys a couple phrases here that we are going to get very used to saying, very used to hearing, that aren't very natural in how we normally talk to people, but they're huge tools in jury selection. One is going to be some people say. We're going to say some people say so that we give the jurors permission to talk, that they are not alone in whatever they want to say. What I think one of the weirdest ones always comes out is, who here feels the same way, even a little bit? And the first time I heard someone say even a little bit, I thought, well, that sounds stupid. The first few times that I keep saying even a little bit, even a little bit, the jury's going to look at me like I'm crazy. But nobody who's been using this has had that problem. And in fact, again, that creates a culture of disclosure. When you to ask someone, if somebody has an extreme opinion and you say, who here feels the same way? None of your jurors are going to raise their hands because they don't have an extreme opinion. They're not to the same level. But when you say something like even a little bit, you've given them permission to say, listen, I'm not going that far, but I think there's a little bit of what they're saying that to me makes sense. And everything that we're doing here builds into that culture of disclosure. And once we start saying that, and once we start creating that, the jurors talk. Because ultimately the question that we're getting to with each juror is, can we agree, or would you agree that this just isn't the right case for you? And this is how we're going to phrase this throughout, because we never want to tell a juror that there's something wrong with them, that they're not an appropriate juror for our case, that they don't get to sit here and listen to our case. But instead, the case isn't right for them. And we're talking about a lot of examples about how we tie in, but ultimately, that's the question that we're going to ask that's going to get us to the cause challenge. When they have a bias, when they have a personal experience that means this isn't the right type of jury for them, that they'll agree. When we've built that rapport, when we've created that atmosphere of disclosure, and we say, we agree this isn't the right case for you, they're gonna agree. This is a very positive experience. It's a very positive exchange of ideas. Now, obviously here in Indiana, we have our jury rules and our statutes, and I encourage you in whatever state you're in to find your own, because you're going to have what your rules are for cause. And you're going to want to find that language that talks about how you identify somebody for bias. In whatever language your state uses. Every state's going to have their own version of it, but if they have an opinion about the case, they have a bias, they have prejudice, they have some aspect that's going to affect their ability to be fair, that's the language you want to get really familiar with, because we're going to build our jurors into talking that way. So getting into that first goal, how do we uncover that bias? Well, one of the first things is we're going to shut up. And this is going to be one of the things that's so different than how we used to do things, where the jury selection is our chance to put on the show, to talk, to indoctrinate, to educate, for us to talk to the jurors, to try to get them to like us. And that's so counterproductive to what we're trying to do here. The goal, much like something that we talk about in direct examination, is to get them to talk. We don't know who they are as people if they don't talk. So one of the hardest things that we have to do is make sure that we are getting them to talk. Everybody's going to speak. Everybody's going to come out, and everyone's going to feel comfortable doing so. Your jurors have to realize that everybody's going to talk. It was kind of interesting as we've been planning this. About 2 weeks ago, my father was selected to sit as a juror on a habitual traffic violator in a possession of meth with intent to distribute case. And my dad, whose son has been in prosecution and worked with law enforcement for 20 years and has heard all of my stories, he wasn't asked a single question. He wasn't asked a single question by the state. He wasn't asked a single question by the defense. And I asked him afterwards, and I thought, did you volunteer that information? And he said, well, they never asked. I figured if they want to know, they would have asked. And so we need to make sure that everybody is going to talk. And to do that, we're going to make identifying and disclosing that bias a virtue. This is a good thing. We want the jury on the same page as us. We are all aiming for the exact same end goal of figuring out who has a bias and why this might not be the right case for them. Not that there's anything wrong with them, but that this case isn't the right one there. So we're going to make sure that when somebody does say something negative, we are thanking them for sharing. During jury selection, we are all on the same team. Us, the defense, the jurors, the judge, we just want to find a group of people that can hear the evidence fairly and reach a decision. So if somebody comes in and they say, I hate cops, I don't trust them, they're the worst. We're not going to fight with them. We're not going to avoid them. We're going to thank them for that disclosure. And we're actually going to talk to them more about it. We're going to say, tell me more about that. Tell me more about your feelings. And again, this is so counter to how we always did things. And, well, I don't want to poison the jury. I don't want this guy trashing cops. But when we think about jurors and how they come in, there's not a single juror who came in that day who didn't have an opinion on law enforcement or cops, who's going to hear that juror and go, oh my gosh, you know what? He's right. I don't like cops. Cops are liars. I'd never thought about it before. That doesn't happen. And so when you have somebody who's talking about that, that is either going to feed into people who feel the same way, or it's going to help you identify which people feel differently. And so that's what we're going to see. Who else agrees? This person says he hates law enforcement. Who here agrees even a little bit? And once this guy has talked about his bad experience or whatever it is, you have someone raise their hand and say, well, I don't hate cops, but I do think some of them are lazy. Okay, tell me more about that. And this is how we get into creating that. I'm going to thank them for that. Thank you. I appreciate that. What do you mean? Can you tell me more about that? Who else here agrees with that? Even a little bit. Who here disagrees? Even a little bit. And this way we start the discussion, not in a way where we're turning anybody against each other. We're not starting a fight. We're just getting all of those experiences out. So that in the end, I'm going to be able to talk to that guy who says he hates law enforcement and say, well, some of the state's witnesses, in fact, all the state's witnesses in this case, are going to be law enforcement. Given these strongly held beliefs that you have, if this is a criminal case involving cops, this might not be the right case for you, given those strong opinions that you hold. And what we're finding is that they're going to agree with that. They're going to say, yeah, if this was a civil case, if this was a personal injury case, I'd have no problems, but I hate cops. Okay, thank you so much for telling me that. And we agree this isn't the right case for you. And we're going to move for that cause strike. So, when we talk about how we open that up, how we create that atmosphere of disclosure, and I've seen so many great ways to do this, but to me, they all get to the same concept that we need to establish with people that bias in this instance isn't a negative trait. When we spend a lot of time talking about what is fair, can people be fair? And everyone wants to say that they can be fair. What does fair mean to you? And then is unfair, is that a vice? Is that the opposite of a virtue? Do we think it's bad if somebody's unfair? Why? And we'll get them to talk about that. Being unfair is bad. Then one of the examples is, my kid is in basketball, and sometimes they don't have enough referees for the basketball game. They'll ask me to ref. And I get up and I say, listen, I'm happy to ref, but this is my kid. He's on this team. And I know the other kids on the team from practice. And I think even despite my best efforts, it's not really going to be fair. I'm going to look at my kid in a positive light because that's my kid and I know these other kids. So while I might be fine to ref any of the other games, I'll ref the next game. I'll ref a game on a different court, but I just don't think that this is the right game for me to ref. And then we're going to ask the jury, who here thinks I did the right thing? And what we're generally is they're all going to raise their hand, even though I'm unfair. Why? And they're going to say that, well, because you identified that wasn't the right game, that you'd have a bias. Exactly. And that's the atmosphere that we're going to try to get. We're getting out of this concept that being prejudiced or being biased during jury selection is a bad thing. It's totally fine. We all come in with those strong opinions, with those common sense experiences, with everything that we've lived that's shaped who we are as people. And it's okay that we have biases. If I'm doing a drunk driving case, I might say, if I have my officer as my witness in chief, and I'll say, if his house was burglarized last week and he was asked to sit as a juror on a burglary trial, what concerns would you have? Well, obviously he's going to be thinking about that. Is that his fault? Do we think of that as a negative? Of course not. And so when he discloses that that's going to be a problem for him sitting in this case, we're going to thank them. We're going to say that's exactly what we're looking for. And what we really want to get to, what we're talking about, what we want to ask the jury that we can't ask them exactly when we're preparing is, what do you think about our case? That's what we want to ask. Do we stand a good chance or a bad? But if there's one thing to take away in terms of how do we do this, and like I said, we have a 3-day case, and we talk about people who get to do jury selection for 3 days before they even start, but also living in the world of misdemeanors and high volume traffic courts where a lot of our DUIs end up, and the judge says you have 10 or 15 minutes to do your jury selection tops. There's one thing to take away is that everything starts with when you're prepping your jury selection, you're saying, and I say, what's the weakest part of your case? What are you the most worried about your jurors thinking? And you're going to say, I'm worried about my jurors thinking X. That turns into your question for the jury. These are not weaknesses. This is not stuff that we need to hide. This is stuff we want to know. Once the trial starts, if your jurors have a view of the weakness of your case, you can't fix it. You're stuck with it. Jury selection is your only chance to get out that bias. So we're going to ask them exactly the question. Some people say, who here agrees even a little bit? Some examples of that. I'm going to worry if I have an OWI and the only substance is marijuana, that we're going to have people who have very strong opinions on that. So I'm going to lead with, some people believe that marijuana shouldn't be illegal and we shouldn't be spending any time prosecuting this. Who here agrees with this? Even a little bit. And you're going to get some people, there's some people who don't, if no one raises their hand, say, who here disagrees? They're going to talk about marijuana. But usually you're going to have some people that agree that marijuana should be illegal. Thank you. Tell me more about that. Why do you think that? Who here agrees? Even a little bit. And we're going to get to that spot where we're talking about the standards, when we're talking about our results. Maybe talk about something where you don't have a chemical test, or you have significant evidence of impairment, but they only blew 07, or poly drug situation. That's the question I'm going to ask. Some people say that you can't know if someone is intoxicated if you don't have a chemical test. Who here agrees with that? Even a little bit. And you're going to get people who raise their hand. We did one version of this course, and I talked to some prosecutors that were really struggling. They were in a legalized state, and they said, our jurors, they just think this stuff should be legal. And so as we talked about this process, ultimately during their jury selections, they started asking their jurors, so you think that the THC in someone's system, that unless we have that evidence, great evidence of intoxication, that the fact that it's in their system, or even if they are under the influence of it, that alone is not enough to convict. And that got them to an ultimate question of, so you're holding the state to a different standard. So this really isn't the right type of case for you. If this was a burglary or a different type of case, your strong opinions on marijuana wouldn't affect your ability to sit as a juror. But given those strong opinions that you have here, this might not be the right case for you. So, we build into that, and it transfers to outside of any of, our impaired driving cases as well. We talk about possession with intent in drug cases. I'm worried that my guy didn't actually hand him over. I'm basing my possession with intent to deliver on the weight of the drugs and the scales and the baggies, but there was no actual delivery done. So I'm worried jurors are going to come back at me on that. You can't know what someone intends to do. That's the exact question I'm going to lead with. Some people say it's impossible to know what someone's thinking. Who here agrees? Some people say that you can't convict somebody of dealing unless you see them hand the drugs to somebody else. Who here agrees with this? Even a little bit. And this is the type of stuff that it's a little counterintuitive, because it's a part of your cases that you're worried about. But when you start asking the jury that I'm worried people are going to think this, they go with you, and you will find out who they are and where they're at. And so what are we looking for when we're asking these questions? We want people's strong, unyielding feelings. We want to know where they're at. We want to know if they have contempt for authority, whether it's the police, whether it's the laws of the land. That's a big one. You'll have a lot of jurors that may be great, sensible people, but there's a law in your state that they don't agree with. And if they're called as a juror on that case, that's a strong feeling. That's an unyielding feeling. If they don't want to follow the law, that's great. That's telling me that we're probably going to be able to get to that cause strike. Whenever they have that strong prejudice, whenever they have those strong feelings, that disclosure is what we want. And so when they make that, we're going to thank them, and we're going to ask them to tell us more. Our jurors do not get poisoned by other jurors. They came in with their own opinions, and just because you're able to avoid somebody saying something during jury selection does not mean they're not going to think about it later. Does not mean that there's someone else on the jury who has that same opinion. It's going to come up, and if they have opinions on it, it's going to bite you if it's something bad. So get it out front. Again, so much of the stuff that we train in trial ad, like in direct examination, what do we always say when you have bad facts? You front them. You get them out so that you can control that narrative, so that you can control how those facts are there. Control picking your jury, control who is sitting on there and who has those strong feelings, and find out who agrees, even a little bit. And that's going to help generate that discussion. So, I've got some Indiana statutes in here. And again, this is just your law will tell you what those ultimate questions should sound like. In Indiana, we have some trial rules that talk about people who have formed or expressed opinions. We dive into our case law. It talks about jurors who, that their opinions will prevent or substantially impair their performance. That, unable to demonstrate a commitment to impartiality. These are all phrases that I'm going to look for, that I'm going to try to get the juror to agree to some non-legalese sounding version of that to protect my record and to make my motion for cause strikes. Really like getting into render an impartial verdict based on the evidence. They can't do that. And take the time, do the research in your state. If you want to steal some of Indiana's ones, we have some great examples. I like that, in this Pinkston case, one of the jurors said that she felt like, given what the other jurors were saying and how anti that crime they were, they felt like they had to sit on the jury just to protect the defendant. That's the type of impartiality now that's not going to be based on the facts. And I'm going to thank them for that. So that is a concern that you have. So given that, the state, we're starting at a disadvantage. Would you agree? So given that, this probably isn't the right case for you. So, just here's a real quick, example of how I would walk that path with the juror. We're going to talk about a recanting victim in a battery case. And I'm going to ask them, if the victim doesn't want to testify and they don't care, then you don't think we should be prosecuting this. Is this something that you believe deeply? Is this something you've thought about before? Might that make it harder for you to find someone guilty of battery? It would be unfair of me to ask you to set aside that opinion, to ask you to set aside that strongly held belief. You want to be fair to both sides. So it may impair your ability to be a juror in this case. And I'm going to lace in some of the language from our cases to say that given that this is a battery and that this is a victim case, maybe this is just not the right case for you. And they're going to agree with that because we've created that, and then we're going to be able to strike them for cause. And everyone's going to sit there and go, that makes sense. And so we're going to use all of our cause strikes, and we're going to strike everybody who shows a bias, even when they're positive for the state. We're not going to sit there and go, well, I'm going to let the defense take care of it. So let me tell you how much it impresses jurors when you've struck somebody who is pro-state but has shown a bias, and they go, wow, they really are just trying to develop a good team. And that's the next part of what we're doing, is building that team. And so who do we want? It's not people who are pro-state. We want people who can work together, make a decision, people who are responsible, invested in their community, and understand they're not going to know every piece. We want that group that goes back, because we're only going forward on a case if we have probable cause and we ethically believe we can win. So if we put out our evidence to a group that can work together, hear that evidence the way that it's intended, and reach a decision, we should be winning all of these cases. That's how it should be going 99% of the time. The main thing that we use to kind of demonstrate a lot of this, it actually comes from a book by Dr. James Rascott. It's an old book from the 80s, New Techniques for Winning Jury Trials, is when some of this came around, but it's color theory. And again, this is the kind of thing that made me really kind of double take when I first heard it. But it is amazing how many people fall into one of four major categories when we're talking about colors. Generally who we're looking for, or who we refer to as blues. And blues, and obviously these lists never fit everybody 100%, but they are really good generalizations. And we encourage everybody to start grading these jurors under this color theory when they get questionnaires, because you can learn a lot from people just based on your jury questionnaires, how they appear, how they come into court. What's nice is, off the bat, 58% of the population are blues. That's why if you've ever heard attorneys say, just give me the first 12 with a pulse and I'll rock and roll, it's because generally 2/3 of the jury pool are fine. And so you're going to come in, they're going to be able to work together, and you're not going to run into big issues. I could spend an hour just on color theory, so I'm going through some of this kind of fast. But so blues, that's the general part. People who use logic can work together. A small part of our population are greens. Greens are our leaders. Greens are blues that have further education. They're more of critical thinkers. They're leaders in their community. They're very community oriented. These are usually the people we want to be our foreperson. They don't have to be the leader, but they will be the leader. You get a green and some blues on your jury, you're in a great spot. But so much of what we're doing when we're asking these questions are identifying that other kind of 25 to 30% of the population. These are our reds. Reds are our bullies. These are dominant, powerful personalities. A lot of lawyers fall into this category. These are the people who are your one person juries. They are going to dominate that room. And this can be a problem, even if they're pro-state, because they're going to alienate other jurors. Lots of times, if you have a hung jury, it's because you ended up with two reds who disagreed with each other. But they are win at all cost type of personalities, and they're never gonna give. And once they start fighting, even if you get a pro-state person, that red is bad for your jury because they're not going to work well with others. They're going to help drive away those other folks. And then that pushes us into our last category, who are the yellows. And when we talk about the yellows, these are people who very emotional, tend to be very artistic, tend to go more with vibes. They have a hard time making a decision. They have so much going on, and they are going to consider so much outside of what just that evidence is. They are going to feel with their heart more than their head. And again, we make it sound negative because they're bad for our jury. It doesn't mean they're bad people at all. It just means when it comes time to make these hard decisions and to sit in judgment of somebody and to work with others and only consider that evidence, they have a hard time with that. That's not how their brains work. So there's going to be lots of times where we're going to go through this. And since we've developed that culture of disclosure and people are talking, it puts us in the spot where we're learning who they are. And the people that we can't get for cause, the people who don't have that very clear, strong bias, that is now, if you're in a state that still has them, where you use your peremptories. And you're going to use your peremptories to get rid of the reds. Most of your reds you'll probably be able to get from cause because they have very strong opinions and they will share them with you. But you're going to have to use some with the yellows because when you're trying to get to cause and this isn't the right case for you, they're going to be like, well, maybe I might. I don't know till I hear it all. Then these are the people that you're identifying as yellows, and you're going to be able to get them off your jury with your peremptories. But all of this boils down to your ability to build that rapport with the jury. And the key thing here is be yourself, be authentic. Don't try to be somebody else. Be transparent and don't waste their time. We think of the entire system as a huge show. We think about it as something where we have to put on this huge performance, that we're going to do most of the talking, that we're going to educate, that we're going to school all these people. That's not what this is. This is us getting together with a group of our peers, because they are. It's a jury of the peers for the defendant. It's a jury of our peers. It's the people in our community. And we're just trying to find people who don't have any other outside life experiences that are going to affect their ability to hear the evidence in this case. And we want to be transparent with that. We're not going to waste their time. We're not going to be cute. We're not going to do shtick. We're not going to, to go back to the case my father was just in, he said the one thing that all the jurors agreed on is that the defense attorney kept telling all these little cutesy stories to open almost everything up, and they hated it. They held it against him. They did not think it was funny. They thought it was a waste of their time, and it made it seem like he was clearly performing for them as opposed to talking to them. That's all this is. It is a discussion. They will respond to that. So know who you are. Know your strengths and weaknesses. Know if you tend to be intimidating. Know if you tend to speak softly. Figure out how to talk to these people in a calm, rational manner. Create that atmosphere of disclosure where everybody is willing to talk. Create this thing where exposing their own bias is a good thing. Talk about their bias. Find out who agrees the same way, and find out which of those jurors will agree with you that this isn't the right case for. With that, I'm going to turn it over to our next speaker, and thank you guys very much for your time and attention.
Good morning. There we go. Good morning, or I guess good afternoon, depending where you are in the country. My name is Ed Hirsch. I am Montana's TSRP, Traffic Safety Resource Prosecutor. I've been a prosecutor for the great state of Montana for about 14 years now, and I'm here to talk about the mechanics of designing your voir dire. We can talk a lot about theory, but often it's hard to go from theory to actual practice, and I am practical, if nothing else, so that's what I want to talk about. I was trained on traditional modes of voir dire. A lot of the stuff Chris talked about at the beginning, and that is how I practiced for the beginning of my profession. As I went on, I started shifting. I didn't know what I was doing, but I was inadvertently moving closer and closer to this style of voir dire that Chris has been talking about, that Erica goes around and they teach about. And they put words to something I didn't know I was doing. And then once they put words to it, I could see and how to unlock the full potential of it. And really, if we want to boil it down, condense it into its most refined, potent form, it's what we're trying to do is diligently excuse for cause in the most agreeable way possible. Agreeable, not pandering, like Chris just mentioned, while seeking a jury panel that is going to work together as a team. That's it. That's the concept. So how do we do it? I'm going to give you step-by-step guides on how to do it. Step one, draft. Write it out. This is not improv. It should not be improv. There are components where I'm responding genuinely to unexpected responses, but the vast majority of what we are doing should be prepared. Step two, practice with real people. We'll talk about this more, but sitting in your office and pondering your questions and pondering responses is not practice. It is not the mechanics of preparing your voir dire. And step three is redraft. We'll talk about this more, but you are never done after the first draft. I promise you. Let's get into it. Here's what we want in our voir dire. Number one, we want kind of an opening statement that sets out the ground rules and does a little housekeeping. I'm going to give you an example in a little bit. We also want a relatable warm-up topic that we can, in an agreeable way, in a non-offensive way, discuss or think about the concepts of bias, right? Most people, when they hear the word bias, they think of the big ones. They think race, sex, all those types of really hot button, like big neon flashing lights. We're talking about kind of different degrees of bias, different concepts of bias. And so we want something relatable that isn't going to immediately be like, well, I can't be biased. I'm the most fair person ever, until you kind of unlock and have a conversation via, quite frankly, the Socratic method about it. The example you're going to hear is about childhood pets. We'll get to it. Then A and B, these first two can be carried over from voir dire to case to case to case. My housekeeping, my relatable warm-up, it's like a dear friend to me. For the dozens and dozens, I think I'm approaching 100 jury trials in my career. I basically use the same one for every single jury trial. After we go through our first two, A and B, then we begin breaking it apart into sections where we tackle important and complex case-specific issues in descending order of importance, but you must always, again, I shouldn't be dogmatic about it. My opinion is you should always address burdens of proof, because if you don't, defense will, and they're going to perhaps muddy the waters on what our burden actually is. So that's my suggestion. All right, let's talk about the ground rules and a housekeeping example. I guess I have a couple jurors here in the room with me. Jurors, would you mind turning on your videos and audio for me real quick, if you don't mind? Juror number one, Ms. Inman, what's your name again?
Erin.
And where are you appearing from today as our juror?
Fort Collins, Colorado.
And juror number two, is that Mr. Grondel? Am I pronouncing that correctly?
Grondel, yes.
Grondel, thank you. And where are you appearing from today?
Hurricane, Utah.
Okay, Utah. And Ms. Graczyk, are you able to join us for this?
Why, yes, I am.
And where are you appearing from today?
I am appearing from Vermont.
Okay. Just so you guys know, audience, not our jurors necessarily, audience, your mileage will vary depending on your jurisdiction, a lot of different components into this. Remember, Judge A can be confronted with one set of facts, one set of rules, and say, hey, you're allowed to do that, Ed. Judge B confronted with the same set of facts, same questions, same rules, and say, Ed, you can't do that. So your mileage will vary depending on judicial discretion. Also, our time is limited, so we're going to kind of breeze through this pretty quickly. I won't have the full opportunity to talk to you as much as I would like. I promise you, I would love to talk to you forever. I bear that as a curse. I'd like to talk. And number 4, why this slide? Who cares about what I just covered? Here's why. I wanted to condition you, my audience, and my jurors to what is about to happen. I started by asking them questions and getting them to respond to me. I've now conditioned them to that this is not just a silent, passive activity. This is interactive. I have also set some ground rules about what we can and cannot do. I'll talk about that more, but I use that with discussions of the law and as well as kind of respect and decorum with the judge. I also have justified controlling the pace. Our time is limited, which means if Ms. Grachik, and I know she is very capable of being very friendly and talkative, if she's going on and on and on and domineering my voir dire time, I only got 30 minutes in front of this judge with his rules. So I have now gotten permission, or I've at least explained why I might have to say, Ms. Grachik, I really appreciate that. I'm going to move on because her time is a little bit limited. And all the other jurors who are sick of Ms. Grachik just going and going and going, and she just keeps going, they're actually going to appreciate it a little bit. I'm picking on Stacy actually because she's very polite and not like that, so bear with me. I also am doing this set to educate you, my panel. This housekeeping, in part, is going to be educating the jury, and that builds credibility and rapport almost instantly in a very efficient way. It's one of the most efficient ways you can build credibility and rapport with your jury. So I'm going to give you my general opening. Good morning. My name is Ed Hirsch. I'm an Assistant Attorney General, and today I represent the people of Park County. As the judge explained, the defendant, name redacted, is charged with the offense of driving under the influence. It's alleged to have been committed on January 1st of 2026. But before we get to that, before we get to witnesses and evidence, right now we're going to go through this process called voir dire. Just to be clear, anything I say is not evidence. Anything opposing counsel says is not evidence. Evidence comes from one place. It comes from that chair. And I pause and I point dramatically at the witness chair. It comes from the witnesses who are going to come forward and swear under oath to tell the truth, the whole truth, and nothing but the truth. It comes from the video, the audio, etc. It's also to point out that the judge is the final authority on the law. I may reference the law, defense counsel may reference the law, but at the end of the day, if there's anything I say that is contrary to the judge, I am wrong. You go with what the judge says, okay? And I say that because I'm going to want to talk about the law, but also it protects me on appeal later on if I ever make a mistake along the way. So this process, voir dire, is to make sure we get a jury that is both fair to defendant and the state. Both the state and the defense are pursuing a fair and impartial jury. We go through this process because everyone, myself, you and I, everyone in this room, we have opinions, thoughts, biases, etc., and that is okay. This process just makes sure that we end up with a jury that can be fair for the facts of this particular case. So I'm going to start with a little bit of an analogy that's going to seem a little bit odd, but bear with me. I promise you it'll be relevant. Show of hands in my jury panel. Who here had a pet growing up?
What was the question?
Who had a pet growing up? Juror number 2, Mr. Grundle, you had Grundell, excuse me. You had a pet growing up?
I had a dog.
Tell me about this dog.
It was a little, I don't know, like a Cocker Spaniel. We called her Tuffy.
Tuffy,
So,
Tuffy the Cocker Spaniel. Great.
Yeah, she was tough.
Okay. This is not the case that we're going to talk about today, but let's work through a hypothetical together. Okay, let's say hypothetically you're called to be a juror on a case. and it's a vicious dog case. Facts are nasty, right? A dog mauls a little kid, a little girl, and you're sitting there, and you're called as a juror. You're sitting there, and you're listening to the facts, the evidence, and all of a sudden, you hear, oh, and the dog's name is Tuffy. Mr. Grundell, is that weird to you?
She was cute and Tuffy.
Cute and Tuffy. Okay. Is it a little weird that this vicious dog case has the same name as your childhood pet?
It is weird.
Yeah. Odd. Anyway, you go on and you hear more of the evidence, and after a little longer, they pop up a picture of the dog in this vicious dog case. And oh my gosh, it is the spitting image of little Tuffy, like Tuffy reincarnated. Wild. Okay, Mr. Grundell, you're an adult, right?
Yes,
You know this isn't your dog, right?
correct.
Okay, but does this feel a little weird?
Feels very weird.
Okay. Do you have like an emotional connection with the memories of Tuffy?
Not anymore.
Well, that's nice. Do you at least get the concept I'm getting at, where that perhaps some of us might struggle to set aside that strong emotional connection, even if it's been many, many years?
Yeah, because my dog would never do that.
Yeah, exactly, right? And can you see how for some people it might mean that maybe they can't be a good juror otherwise, but for this particular case, maybe this isn't the best case for them? Does that seem fair?
That's fair.
Show of hands, does anyone feel otherwise, maybe even a little bit? Okay. That is a bias example topic, right? Chris used to talk the concept about the basketball game, reffing the basketball game for his kids. That's the one I use. There are many different variations. And once you find one that works for you, use it. Remember, try not to be pandering. Mine kind of walks the line a little bit sometimes, but I have a personality where the jurors have given me the grace to get away with it. So if it works for me, I'm not going to change it. Find what works for you. After we've gone through our ground rules and housekeeping and our warm-up to talk about bias, then we tackle the complex specific issues. And I suggest you build it in this process. You identify the complex or important issues for your case in descending order of importance. Next, I prefer an experiential voir dire. And what that means is we want to use experiences or analogies that almost all your jurors are going to relate to. So we take our issue and we brainstorm a broadly relatable analogy. Then we write our questions to walk the jury through the issue using the analogy. You're right, because we can't use facts too close to the facts of our case. But analogies and hypotheticals that are far enough removed are allowed. So, for example, before we get that, when you're doing this, if you want to add another level, beyond just the basics, right, our primary goal is to get that state of mind where they can be impartial for our case. If we can also add in a little bit more, this is some traditional concepts, but we're adding it on to our more modern concepts of voir dire. If we can frame the issues and introduce some language so they understand what we're talking about, for example, the concepts of what does under the influence mean, or something like that. We also can build rapport if we do this well by demonstrating competence and establish trust that I'm not going to be offended no matter what you say. And then also, we can compensate, especially in our misdemeanor courts where we have no budget, we have no time, where it's go, 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 jury trial, jury trial, jury trial. You don't have time. We can, in some ways, compensate for not having the funds or ability to call expert witnesses. So, in an example, in a DUI case, we're going to talk about under the influence. I'm going to call upon my jurors again to go through this. I've gone through my family pet example for our purposes here. All right, let's shift gear. This is a DUI. I'd like to talk about signs of alcohol impairment. Show of hands, has anyone ever seen someone who's had too much to drink? Perhaps they've been overserved or something. Show of hands. Ms. Inman, have you ever been in an event like a wedding or something like that where someone's had too much to drink?
Yeah.
Okay. Why did you think that?
Why did I think that they'd had too much to drink?
Yeah.
They weren't acting normal given the social situation. So they were loud and obnoxious and shoving people around and wanting to be
Okay,
shoved
they're
around.
getting
So
rowdy. Okay.
yeah, yeah,
So you looked at the way they acted.
right.
Okay. And Ms. Grachik, have you ever been around someone who's had too much to drink?
Yes, definitely.
How did they sound? What was that like?
Definitely sound, their speech is like slurred,
Uh-huh.
or they say the same things like over and over and over again. They forget they already said it.
Okay, so you considered like not just the words they were saying, but the manner in which they said them, right?
Yes,
Did that seem fair to you?
yes,
Okay, and Mr. Grundell, uh, have you ever been around someone who's had too much to drink?
Yes.
Uh, can you tell me about their appearance? Was there anything visible you noticed about
Appearance, they looked kind of sloppy,
them?
had kind of that droopy eye, that face, flush, and they really just almost emotional. They go really happy and then they're really sad, and they're happy and then they're sad.
Okay, so we've considered the way they acted, how they sounded, the way they appeared. We've kind of taken in everything in together. Ms. Inman, did you think the person you observed would have been safe to drive?
No.
Why not?
They clearly had had enough to drink that they were making poor choices, and I don't think they could control a vehicle well.
Do you think your conclusion was fair? Your thoughts on that were fair?
Yes.
Okay. Did you need a scientific test to make that
No.
determination?
No.
Okay. Ms. Grachik, for your individual you were thinking about, did you think they were safe to drive?
definitely not.
Okay. Did you need a test for that?
Oh no.
Okay. Mr. Grondell, let's talk about driving. We're driving here. We've got our steering wheel in our hand. What are you doing with your hands while you're on the road?
Steering, either
Okay.
10 and 2, or so
Yeah.
that either both on the hand, on the wheel, or maybe you've got just one hand.
What are you doing with your eyes?
Scanning, looking down the road, side mirrors, rearview mirror.
And what about your feet? What are your feet doing?
Well, the right foot's either on the gas pedal or on the brake, depending upon the circumstance.
Yeah. Okay. So we're kind of coordinating a lot of things. We're kind of
Yeah.
coordinating our senses, our arms, our legs, a lot of different components at once. Do you actually think about that when you're driving?
Not anymore. It's just like second nature.
Yeah. Um, do you think clear and quick thinking is important for driving?
It's essential.
Yeah. What if a deer jumps out in front of you? You're in Utah, elk.
Yeah, you got to either stop quickly or maybe you can steer around it, but you've got to react quickly.
Okay. Do you think alcohol could affect or diminish your ability to have that quick thinking reaction times?
Absolutely.
Okay. Ms. Inman, how about that decision when you're driving along and the light in front of you goes from green to yellow? How do you make that decision to hit the gas or hit the brakes?
Yeah, that's important.
What do you take into consideration?
Whether or not I will make it through the intersection legally, depending on the state I'm in, the
Uh-huh.
law is,
Uh-huh.
and whether it's safe to do so
Okay.
whether it's safe to stop, whether it's safe to go through the intersection.
Do you think that decision could be affected by alcohol?
Absolutely.
Okay. Now I'm not the authority on the judge. Like we talked, excuse me, I'm not the authority on the law. Like we talked about, the judge is the final authority on the law. What I believe the judge will tell you is that in DUI, a person is under the influence if, as a result of taking the body alcohol, a person's ability to safely operate a motor vehicle has been diminished safety. Ms. Grachik, do you think it's fair or reasonable that the law in Montana for DUI is just diminished safety rather than like drunk or anything like that?
And it makes sense to me.
Okay, why?
Well, because different people could be not safe to drive at different levels, I guess. Like I think about myself, like I probably wouldn't drive after one. Some people it might
Yeah.
be different.
Yeah, and it's ultimately, does it feel fair that it's a preventative safety measure? That it's just that diminished safety rather than drunk?
Oh, definitely. Yeah.
Okay. Does anyone feel otherwise, maybe even just a little bit? And onward and upward, et cetera, et cetera. Right? We've just dove into like 90% of our DUI topics in about 7 minutes worth of voir dire. We've opened up the floor for those red and yellows who maybe don't like that or want to be loud and have strong opinions about that, to pull them out and identify them. Our three jurors here, they seem like they're probably going to work together pretty well here. I'm not really concerned about them, but that we can do with almost any issue using those experiences or analogies. The deer jumping out. You're at a party and you see someone who's had too much drink. Making the decision on the yellow light. That's what I mean by experiential, and you can do that for any issue in every case. Thank you, jurors. I think that's all I need for you. I appreciate it.
Thank you.
Right? We met our purposes of pursuing state of mind. We also, secondary purposes. We talked about issues, we build rapport, and we use them as experts about, we're not just looking at a BAC, we're looking at sound, actions, judgments, etc. Then you need to practice with real people. I cannot stress this enough. Practicing in your office is not the same. And this is by far the most fun part of trial prep. Thinking it through is not sufficient. Go find your friends, family, coworkers. This is the only part of our job that they actually find interesting. When you're delving into those weird issues, like, what is reasonable in justifiable use of force? What is under the influence when driving? Why actual physical control? That's the stuff, like the almost philosophical questions, that's actually interesting about our job, and the rest of our stuff is, quite frankly, boring to them. And being able to respond to those unexpected responses and not be judgmental is the art of it. So you need real people for it. Oh, also, they're going to tell you when it's not working. They will tell you, and you'll feel it and you'll know it. And listen. If they're telling you it doesn't work, ooh, boy, howdy, listen. I have made the mistake of not doing that and not going back to the redraft, which is a critical important, because you're thinking it's going to work in your office. You practice with real people, and it doesn't. Please practice with real people. I once made a fool of myself because I was convinced this thing about bears. There are a lot of bears in Montana. Some people love bears. They have a teddy bear. I have had a couple encounters with bears, and as a result, when I'm stressed at work, I have bear anxiety. So I try to use this concept of an encounter with a bear to talk about fight, flight, or freeze in a domestic violence case. Everyone I practice with were like, Ed, this isn't working. But I knew better than them. And panel, I did not know better than them. So when your friends and family and coworkers are telling you, this one's not really hitting, listen to them, go back to the drawing board and redraft. I'm going to give you just a couple don'ts. Please, please, please do not ask questions that have a specific answer that an average citizen wouldn't know. What I'm primarily talking about is legal terms with definitions. Do not ever ask a juror, what does beyond a reasonable doubt mean to you? Lawyers, can you off the cuff very succinctly and accurately define beyond a reasonable doubt? Maybe, hopefully, you get a certain point in your career, but asking a juror what they think the law is does not work. It sets them up for failure because they're probably not going to be perfect on it. Also, then you're going to have to criticize them and be like, oh yeah, good thought, but you're not quite right. All the other jurors are looking around and like, oh, this test has wrong answers? I don't like that. It also wastes your time correcting the juror on what the law actually is. Then it chills all further responses. Hey, there is a deer outside my window just walking by right now. I love Montana. It's fantastic. Please, everyone, come vacation here. Spend your money and then leave. It makes it great for us. Also, when you talk about legal definitions that without giving them at first, it raises a specter of incorrect legal standards. You don't want it. So instead, if you do have to talk about legal terms, rely on uncontested jury instructions and frame it as, now, the judge is the ultimate authority on the law. And what I believe the judge will tell you is that the definition of under the influence means X, Y, and Z, or the definition of beyond a reasonable doubt means X, Y, and Z. And then ask the jurors how they feel about that. Thank you for your time, and Stacy is up. I appreciate you all.
Hello, everyone. So, we've heard a lot about the preparation for voir dire. We've heard about all the things that you need to do beforehand. But one of the things to keep in mind, particularly if you've never done a trial before, never done a voir dire before, is that the whole thing is really a credibility contest. That's what jurors are looking at. They're looking at who is credible, who can I rely on, who's the expert here, who's the one I should trust. So it's good to be mindful about that when you're going into your voir dire, because that is your opportunity to establish credibility. That's your opportunity to show that you're the one that they should be relying on. You're the one that they should look to. So to that end, you need to be mindful during the whole entire voir dire process that jurors are watching you. They are watching you like a hawk, especially if they're sitting there all day long. People get bored. They're watching everything you do, how you're treating the court staff, how you're treating the defense attorney, how you're treating the jurors. So it's really important to be mindful of that. How you're treating just, the janitor in the building. If you're in, depending on what your jurisdiction is like, you could be using the same bathrooms that the jurors are on breaks. You could be going to the same restaurants or stores on breaks to get food for lunch, something like that. Really be mindful about the behavior that you're showing, because this is their first impression of you, and you want to establish that you are someone to be trusted. So be the hero, and just keep that in mind throughout. It'll go a long way. Let's see. Let me get to our next one. Okay, next. It's really important too to know the rules. When you've never done picked a jury in your courtroom, your jurisdiction, you want to do your homework beforehand. You want to make sure that you know how that court typically has things done, how that particular judge has things done. What are the things they like, what they don't like? For instance, I had a case. I worked in one county for years and years, always asked the same question. And then I went to another county, and this judge absolutely does not like that question. Do your homework beforehand, because again, when we're referring back to that credibility, when you go in there and you know the rules, you know the playing field, you know what's going on, that boosts your credibility in front of that jury panel. So know, for example, like what are written questions permitted? How do you handle sensitive questions? That's something to think about. Is a question you're asking going to elicit a potentially sensitive response, sensitive subject, such that you want to protect that juror, honor, respect their privacy? That's going to go a long way towards that credibility with your jury. As well, the undertow rule, to the extent at all possible, have someone else sitting with you while you're doing voir dire. Have someone, it could be a colleague from your office, It could be the investigator from your case, or if you have an investigator in your office, it could be an intern. You may have law school interns. When you have this giant group of people, and the most important thing is to establish that connection with them. You're wanting to pay attention to everything they're saying and all the things that they're not saying. A lot of voir dire is sort of looking at those nonverbal cues that jurors give us. Could be, they cross their arms on something, they might roll their eyes at something someone else said, they could be shaking their heads. It's really hard to be paying attention to all of those things while you sort of have your script and the things that you're trying to capture and you're trying to take notes about people. The last thing you want to create is where folks on the panel feel like they're being interrogated or examined by a doctor or something where you're taking notes of what they're saying. So if you can have someone taking those notes about the nonverbal cues and all the different things so that you can focus on having that conversation, it's really, really helpful. It can really go a long way. Oops, skipping ahead here. So the Batson rule. Oh, develop a system that works for you. You definitely want to have a system that you have down. I use this example with the Post-it notes because that's what I ended up using. I sort of tried, watch more experienced prosecutors before I drew my first jury, and tried out different methods, and this was the one that worked for me. But have a system that works for you where you're keeping track of those jurors, maybe how they pronounce their name, different observations, things like Chris mentioned earlier, the personality traits. If it comes out, someone's clearly a blue or a green, yellow, red, you could have shorthand, so that you can work faster. But develop a system that works for you so that you have what you need, to make your determination at the end. And Batson case. If you've not read this case, you definitely want to be familiar with it. So this is a U.S. Supreme Court case from 1986. And in this case, the Supreme Court found that while a defendant is not entitled to an entire panel of their own race, they cannot have jurors excluded based solely on race. So when we have our challenges for cause, we have our peremptory challenges. Those peremptory challenges, they cannot be for race, or since Batson was decided, it's been extended to other any protected class, like think gender, religion, religious affiliation, ethnicity, national origin. Aaron had mentioned earlier we had a QR code, and I think it was also in the links for our jury monograph that accompanies this. There's a whole section that you can read about Batson so that you can be familiar with it, but it's definitely something that you want to know before going in to do voir dire. And lastly, the Nike rule. We have all this preparation that we do going into jury. You can have all the questions, all the things that you want. You could have watched tons of different, more experienced prosecutors select a jury, which I definitely suggest that you do before you pick one, to just get an idea of different styles, different takes on it. But at the end of the day, just do it. You don't want to be so wedded to scripts and questions, and we all get so nervous, and you're definitely going to be nervous before you draw your first jury, but you don't want to be so nervous and so worried that you're just wedded to the script and you're just staring down at a paper and sort of missing out on having this conversation with the jury, establishing your credibility, and listening to them. That's the most important thing. You really want to be able to listen to what they're saying. When you're so wedded to notes, you may miss that there's something, an offhand comment someone made that you could follow up on. So really, at the end of the day, just get up there and do it. You will find what works for you, and to get your good jury. And so just get up there and do it. And that is the last slide for me.
Thanks. I'm going to open it up to, oh, sorry. Did I interrupt somebody or was I getting feedback? Okay. We're going to open it up for questions. We don't see any in the chat, which is totally fine. I did have a couple questions, because I had the advantage of having seen this content a couple of different times with these presenters. And so, Ed, my first question is for you. And in fact, before I start questions, can I ask that the presenters go ahead and turn on your cameras and your microphones, and feel free to chime in. We only have a couple of minutes here, but Ed,
Was this
you
attendance
mentioned
check? I'm here, I swear.
you mentioned a couple of times, Ed, descending order of importance. And when I was taught originally about really anything having to do with trials, it was stressed over and over again, primacy and recency. So you want to do your most important fact or issue up front, and you want to close similarly with an important fact. But why are you saying go in descending order of importance?
Yeah, I guess in my mind, most of the people who would be pursuing this type of training would probably be newer in their career, and probably in misdemeanor world. And I assume in most your misdemeanor jurisdictions, in front of most of your judges, you have really tight time limits depending on your judge. Some of the judges I've practiced in front of have given you 15 minutes. Some have given you 30. Right? I primarily handle DUI homicides now, so I can kind of ask for as much as I want within reason. But especially in misdemeanor world, you got 30 minutes to talk to 32 jurors in my panel and be able to figure out as much as I can about them, whether they're going to be a good teammate or not. And so I just couldn't afford to run out of time. So that is really comes down to if you have that time limit or not. And also, don't bore them.
Okay. Thanks, Ed. Chris, I have a question for you. Again, I go back and I was taught indoctrination is an important part of jury selection, and that the jury has made up their mind on your case before you even give your opening argument. In other words, they make up their mind in jury selection. Have you completely abandoned now after having used your system, the indoctrination concept? I know you touched on it. I just wanted you to elaborate just a touch, please.
I'd say a jury that makes up its mind before your opening statement made it up based on their biases and all the stuff that they came in with, right? I mean, if you're subscribing to that theory, it's because they're coming in with a really strong experience. And so if you believe that concept, that makes it all the more important to figure those out when you can still strike them. Because if they've made up their mind about your case and it's not the answer that you want to get them off before the case starts, right? So from that concept, yeah, we're not trying to indoctrinate them a certain way. We're trying to figure out if they do have those beliefs before we've even started presenting the evidence, because they shouldn't sit there. I will draw a distinction though, because there is always still a point that there are some concepts that you're going to have to educate a jury on, and so we haven't abandoned that entirely. If you have something like constructive possession, as part of your case, that's a weird concept, and you can't ask the jury what they think about it when they don't know what it is. So there is still a part, there's some of these things that we're going to have to educate them on some so that we can find out if they have feelings about it. But the vast majority of what we talk about, if you've already won or lost during jury selection, it's because you either brought in people who had a bias for you or didn't have a bias at all. And we want to eliminate those biases. We don't want to be winning based on people who have a bias. And again, you may still have people who are biased for you, but if you have someone else who's biased against, you're going to hang.
All right, thanks. So we do have one more question, Darren. With your permission, I'll go ahead and ask this last question, or we can wrap it up and the panel can answer outside. I'm not hearing from Darren.
You may
So I'm going to
proceed.
Thank you, sir. Should we be asking about biases? This is from the chat. Should we be asking about biases toward law enforcement in our voir dire, or should defense counsel be the one asking about that during defense counsel's voir dire?
I mean, I think you want to be the one to ask about it. Same way that during your direct examination, you front your bad facts. And again, it's a very powerful message to the jury what your purpose is in jury selection. If you bring out the fact that someone has biases against them, you ask them. You want them to talk about it. You invite them to disclose those biases. They're like, oh, he's not just trying to hide the bad stuff and make his side sound better. He is actually looking for those biases. And then when you get someone who is biased in favor of law enforcement and you end up being the one who strikes that person for cause, man, that earns you so much credibility in that building with the jury in terms of they really are just after a group of people who aren't coming in with biases.
All right. Thank you. I will now turn it over to Mr. Grandel. Thank you. Thank you, team.
Well,
Darren,
thank
it's
you.
all yours.
Well, thank you very much, Aaron, and thank you, Ed, Chris, Stacy, and I know we have Erica in the background. And so thank you very much for the whole National District Attorneys Association, National Traffic Law Center for all the work on this webinar. I did have one question because I am the moderator or the host of all this. But when I was a young trooper, I was asked to actually help support the prosecutor in choosing a jury. Do you ever have that happen? And do you recommend that?
You want me to take this one, Chris, or
Yeah,
Stacy? It's up to you guys if you have opinions.
go for it, Ed.
I love it. I love it so much. Here in Montana, we do have an asterisk, which is it is in, I would say, the light gray area where the vast majority of judges do allow that because we don't represent a person, we represent the state. So we're allowed to have our investigator in with us. Some judges, because we've got some gray area, will not allow it. But there's no faster way to train your trooper than have them sit through an entire jury trial. And two, they deal with people all day, every day. They will pick up stuff I would never notice in a million years. That's my 2 cents on it. Stacy, Chris, take it away.
I think I definitely agree that it's great to have, but it's also to remember too sort of the where they're coming at with it, right? They may have their own biases that they have or their own sort of approach, right, that's different from a prosecutor's. So I think it's, yes, definitely having a second person there with you, period, is good. But just being mindful of sort of where that person is approaching it.
Agree.
Chris, you were going to say something?
I agree.
Yeah, and that was one of the things that, as you know, as a trooper, we were never training in some of that. You know, we do some courtroom training, but to go through voir dire and all of that. But it was interesting to be able to, as they were writing and we're looking up, sometimes when you look down to write something, things are done. There's some expressions, some nonverbal cues. So overall, I that's why I wanted to bring that up because I think it's always important to have a second. But it was fun for me because I learned so much in that process and how to actually improve how I did my own cases. So
I had an officer who referred to it as the equivalent of a ride along. If you're a prosecutor who has ever done a ride along with the cop, this is the inverse of that. It's them doing a ride along with you through a trial.
yeah, yeah. So, great. Thank you so much. Responsibility.org is truly honored, and it's a privilege to be able to work with so many great partners and being able to have and host these webinars, but also the publications and resources. There's trainings. For those that are on the call, if there's additional trainings or things that you would like to see, there's some opportunities there. So I know, Aaron, you and your team have done a lot of work around the country on this and continue to do that to enhance this because this is a truly 100% preventable crime. And how do we help to address this? And so we just appreciate all of the resources and all of your time today. Just as we close, we will be sending a follow-up email with some of the information and a recording to today's webinar. Please share that with others in your office and with others that you know or maybe need to have this training. So, but once again, thank you. Thank you to our team at responsibility.org because as we know, drunk and drug driving are out there and we have to address that. And that's our whole mission or what part of our mission at responsibility.org. So thank you very much. and have a great week.